Welcome back to the deep dive. We're here again to cut through the complexities, especially when it comes to the MPP, the Manual of Patent Examining Procedure.
That's right. Our goal is always to give you clear, concise walkthroughs.
Exactly. Helping students, practitioners, anyone prepping for the patent bar exam, really, turning that dense material into something you can actually use.
And today we're diving into MPP Section 718. It's in Chapter 700, which covers examination of applications.
Okay, Section 718, what's the official title on that one?
It's titled Affidavit or Declaration to Disqualify Commonly Owned Patent as Prior Art, and it refers to Rule 37 CFR 1.131C.
Right.
Now, this is a pretty narrow procedure, but really important for overcoming certain kinds of rejections, particularly for applications still under the older pre-AIA rules.
It's kind of wild, isn't it? The whole idea that, your own company's previous patent, your own hard work could actually block your next invention.
It does sound counterintuitive.
Totally. Like, how does that even happen? So yeah, let's definitely unpack that.
Okay, so first things first, context is everything here. This rule, MPP 718, it only applies to patent applications filed before a very specific date.
Right.
March 16th, 2013.
Ah, the AIA date.
Exactly. That's when the American Invents Act, the AIA, really kicked in and changed a lot, especially how we look at prior art in the U.S.
So even though the law changed back then, this older rule, it's still relevant.
Absolutely. Think about it. There are tons of patents still active and maybe even applications being examined that were filed before that 2013 date. They're governed by the old rules.
Okay, that makes sense. It's like dealing with an old house, right? You still need to know the building codes from when it was built, not just the new ones.
That's a great analogy.
Mm.
You can't ignore the history. It still dictates how things work for those older filings. So understanding 718 isn't just academic, it's practical for managing existing patents.
Got it. So let's paint the picture. What's the specific problem that MPP 718 solves?
Okay, imagine you're an applicant. You've filed your application, and you get an office action back from the USPTO.
The dreaded rejection.
Right, and the rejection is under 35 USC Section 103, meaning the examiner thinks your invention is obvious.
Okay, standard obviousness rejection. But what's the twist?
The twist is what they're citing against you. It's not some random publication or a competitor's patent. It's a U.S. patent, or maybe a published application that your own company owns.
Ah, so it's friendly fire, essentially.
Pretty much. And there are a couple of key conditions here. First, this commonly owned reference, it isn't what we'd call true prior art under Section 102B. Meaning, for example, it wasn't published more than a year before you filed your current application. If it were, well, that'd be a different problem entirely. The issue here arises because you own it.
Okay.
And the second condition is that the claims in your new application are considered not patentably distinct from the invention in that commonly owned reference.
Not patentably distinct.
Okay.
So similar, but not identical.
Exactly. They're seen as obvious variations. If they were identical, that would be an anticipation rejection under Section 102, and this MPP 718 procedure wouldn't help. This is specifically for obviousness.
Okay, so it's got to be obvious based on your own commonly owned prior work, and that prior work isn't a 102B bar.
You nail it.
The MPEP actually gives an example, right? Like an inventor files a first patent on a system.
Yes, and then files a second application on an improvement to that system, both owned by the same company.
But the improvement, the claims for it, they're considered obvious in light of the first patent.
Correct. The examiner says, look, given your first system patent, this improvement is just an obvious next step. That's a classic Section 103 rejection using commonly owned art.
Which, if you think about it, could happen a lot with incremental innovation.
It absolutely can, and it raises that big question.
How do you stop your own company's progress from tripping over its own feet, patent-wise?
Precisely. And that's where MPP 718 comes in as the solution.
All right, so you've got this rejection. Your own patent is cited against your new related invention under Section 103. What do? What's the strategy MPEP 718 lays out?
It's a specific two-part strategy to basically disqualify that commonly owned reference as prior art for the purposes of that obviousness rejection.
2 parts. Okay, what's part 1?
Part 1 is filing what's called a terminal disclaimer. That's under 37 CFR 1.321 CBER.
A terminal disclaimer, what does that mean practically?
It's a formal statement you file with the USPTO.
Yeah.
In it, you, the applicant or owner, agree that if the current application issues as a patent, its term will end or terminate on the same date as the earlier commonly owned patent or application that the examiner cited.
Ah, so you're basically linking the expiration dates. Why is that required?
It's all about preventing something called non-statutory double patenting, sometimes called obviousness-type double patenting. The USPTO doesn't want you to get an extended period of patent protection for what's essentially an obvious variation of an invention you already have patented or have claimed in another pending application.
So, even though you invented both, you can't stack the patent terms for obvious variations.
That's the core idea. The terminal disclaimer says, okay, fine, these are related enough that they should expire together. It ensures the public gets access to the obvious variation at the same time the original invention's patent expires.
And who signs this? The inventor.
Usually the owner or the assignee. You need to show the chain of title, proving common ownership for it to be accepted.
Okay, that makes sense. Ownership is key. Now, here's something interesting I noticed. Filing the terminal disclaimer isn't enough on its own, is it?
That's a critical point. No, it's not. A terminal disclaimer by itself isn't considered a complete response to the rejection.
So what else do you need?
You also have to file a request for reconsideration of the office action. You need to actually argue against the rejection, maybe explaining why. With the disclaimer and the affidavit we'll discuss next, the rejection should be withdrawn. Just filing the disclaimer form doesn't cut it.
Right, you have to actually ask them to reconsider in light of the disclaimer. Good procedural tip. Okay, so that's part one, the terminal disclaimer. What's part two?
Part two is submitting an affidavit or declaration under 37 CFR 1.131C. This is often called the prior inventorship affidavit in this context.
An affidavit or declaration, like a sworn statement.
Exactly. It's a formal statement made under oath or penalty of perjury, submitted to the USPTO, providing specific facts.
Okay, facts. What facts does this declaration need to establish?
It has to assert two crucial things. First, pretty straightforward. It needs to state that the invention in your current application and the invention in that commonly owned reference patent or application are in fact currently commonly owned.
Verifying the ownership situation again makes sense. What's the second thing?
The second assertion is the really interesting one, and it goes to the heart of why this exception exists under the old rules. It must affirm that the named inventor in your current application is the prior inventor of the subject matter claimed in that reference.
Wait, say that again. The inventor of the new application has to be the prior inventor of the stuff in the old reference.
Yes. You're basically saying the person who invented this new thing also invented the relevant subject matter in that older patent before that older patent's effective filing date.
Huh. So it's not just common ownership, it's common inventorship lineage in a way. You have to trace it back to your current inventor being the first one for the relevant concepts.
That's a good way to put it. It leverages the pre-AIA focus on first to invent. You need to declare that your inventor conceived of the invention or reduced it to practice before the effective date of that commonly owned reference.
Wow. Okay. And who signs this declaration? The inventor again? Or the owner?
It can be signed by the inventor or a legal representative or the assignee assignee, the cursor.
No, and this doesn't run afoul of the no new matter rule because you're adding the statement after filing.
Good question. No, it generally doesn't. The rule against new matter prevents adding new technical information about the invention itself. This affidavit isn't changing the invention.
Ah, I see.
It's providing factual background about the history of the invention, who invented what, when, and who owns it now. Those facts are relevant to overcoming this specific type of rejection under these specific pre-AIA rules. It's context, not new technical disclosure.
Okay, that distinction is important. So this whole process, terminal disclaimer plus the affidavit, sounds powerful but very specific. What are the absolute limits? What can't it fix?
This is probably the most critical boundary to understand. MPP 718 is crystal clear on this. You cannot use this procedure to disqualify a commonly owned reference if that reference anticipates your claims under Section 102.
So if the older patent identically describes what you're trying to claim now, tough luck.
Exactly. This only works if the rejection is for obviousness under Section 103. If your earlier patent already shows the exact same invention, you can't get a second patent for it using this method. That would be improper double patenting, plain and simple.
That's a really sharp line. Obviousness, yes. Anticipation, no. Got it.
And just to hammer it home one more time, this entire mechanism is only for applications filed before March 16, 2013.
Right, the pre-AIA window.
If your application was filed on or after that date, you're under the AIA rules, and the way common ownership is handled is different.
Which brings up that contrast again. How does the AIA handle this? Why don't newer applications need this 131C declaration generally?
Well, the AIA introduced a provision, 35 U.S.C. 102BC, Broadly speaking, it creates an exception to prior art for subject matter that was commonly owned or resulted from a joint research agreement by the time of the effective filing date of the claimed invention.
So under the AIA, if it was commonly owned early enough, it's often just not considered prior art for obviousness purposes, without needing the special affidavit.
That's generally the idea, yes. Section 102B2C provides a more direct route to exclude that commonly owned disclosure from being used against you, typically without needing that declaration about prior inventorship that 1.131C requires.
Interesting. So the AIA sort of streamlined this particular issue.
In many ways, yes, which really highlights how MPP 718 is this specialized tool, essential for navigating those older pre-AIA cases, but not the standard approach anymore.
Okay, this has been a really detailed walkthrough, so let's bring it back to the listener. Why does understanding this specific, maybe somewhat historical rule matter to you today?
Well, for starters, it's practical knowledge. If you're involved with patents filed before March 2013, maybe prosecuting them, managing them, valuing them, you absolutely need to know this procedure exists. It could be the key to overcoming a rejection.
Right. And for anyone studying for the patent bar exam or just trying to get a handle on patent law fundamentals?
Oh, it's invaluable. Understanding 718 really deepens your grasp of how the law treats inventorship, ownership, and prior art, especially across different legal regimes like pre-AIA and post-AIA. It explained how companies could and can manage their own innovation pipeline without hitting self-inflicted roadblocks. It's a real light bulb moment for many students.
And for practitioners working today?
Knowing this mechanism is a strategic tool. It can literally save a patent application that might otherwise be rejected based on the company's own earlier work. It shows how knowing the detailed rules, even the older ones, can lead to successful outcomes for your clients or your company. Careful planning pays off.
Okay, so that brings us to the end of our deep dive into MP, Section 718, Affidavit or Declaration to Disqualify Commonly Owned Patent as Prior Art.
We covered that crucial pre-AIA context, the specific obviousness rejection scenario it addresses,
And the two-part solution. The terminal disclaimer under 1.321C and that critical affidavit of prior inventorship under 1.131CE.
And crucially, we highlighted that line between obviousness where this works and anticipation where it doesn't.
It really makes you think, doesn't it? How these specific rules, born from a particular historical context like the old first-to-invent system,
How they continue to echo. They still shape existing patent portfolios and definitely influence how companies think about structuring their IP disclosures and filings, even today. It poses an interesting question. How much do these legacy rules still subtly guide modern patent strategy?
something to ponder. Before we wrap up, we definitely want to give a special thank you to Mike Sheppard. He's the creative director who organized this entire MPP audio series.
Absolutely. And just the standard but important disclaimer. This summary was generated using AI tools like ChatGPT and NotebookLM. It might have errors or omissions. It's for educational and informational purposes only. It is not legal advice.
Please don't rely on this instead of formal instruction or advice from a qualified professional.
For the authoritative word, always consult the official MPEP itself, talk to a qualified instructor, or speak with a registered patent practitioner.
We hope this deep dive into MPP 718 was helpful. Join us next time as we continue exploring the fascinating details of patent law.